can get started. So welcome everyone to this presentation, this panel entitled "The State of Deference in the States: The End of Deference." I'm really excited to be here, be doing this panel. Thank you to the ABA for hosting it. I'm Daniel Orkner. I'm an attorney at the Pacific Legal Foundation. The other panelists today are Matthew Barron, who's with Jackson Lewis PC, Adi Dinar from the New Civil Liberties Alliance, and Aaron Sager, who's a professor at Fordham University. I should mention that originally Lisa Sorinen from the State and Local Legal Center was supposed to be part of our panel, and then she had to drop off for, she had a conflict and couldn't be part of the panel, so we regret that she's not able to join us as well. Want to encourage everyone to use the Q&A to ask questions. We'll be seeing those and responding to them towards the end, and really excited for the discussion and the conversation. And want to also say that the views that we are going to be expressing in this panel are going to be our own, not that of the ABA or anyone else's, but our own. And with that said, really excited to be doing this panel to discuss what is a important topic that I think is rightfully getting a little bit of the attention that it deserves. I have a lot of scholarship, a lot of conferences and panels talking about deference at the federal level, Chevron, Auer, Seminole Rock. These topics get rightfully a lot of attention, a lot of briefing at the U.S. Supreme Court. You have really strong opinions about whether these doctrines are consistent with the rule of law, whether they're aligned with the role of the judiciary, whether they are proper or not. A lot of great scholarship on the topic. But what's been, I think, a little bit neglected has been deference at the state level. And what's been happening, and really there's been a significant trend of states really grappling with the question of, should we continue to defer to agencies? And a lot of different decisions, a lot of diversity of outcomes in states. A very noticeable trend of states rejecting deference, and also some states that are nuancing or limiting their use of deference. And so we're excited to discuss that. I'm going to just go first and do an overview of state deference based on my 50-state survey of what's happening at the state level, talk about some of the trends and some of the patterns. Then we're going to have, after that, Adi is going to talk about, he's at the New Civil Liberties Alliance, been doing a lot of, fighting in a lot of states over the topic of deference and working also on the legislative side. And so he's going to have some very unique insights about the battle that's been happening in different states. After that, Matthew is going to talk about his expertise of Ohio in particular. He has a lot of knowledge about the situation there, and it's a state, one of the states that's very interesting. The debate that's happening in the judiciary in the state of Ohio right now is I think illuminating of the disagreement that's happening in the judiciary and in the profession over the topic of deference. And then finally, Aaron is going to discuss reasons why states should be taking their own approach ultimately to deference, re-examining the topic, not just following the federal government's, federal judiciary's cues on deference, but forging their own doctrine and some of the doctrinal, the reasons that is the right approach. So looking forward to that, and then we'll have time after that to open it up for questions and discussion. And I'm really looking forward to hearing the comments and discussing each other's presentations as well. So to start talking about what's been happening at the states, I want to share, hopefully on the screen, a picture of some maps that are color-coded that I think are going to be good for illustrating this. 1 second, I need to find the right one. It vanished. It's not giving me the option now. Let's see. Excuse me. There we go. So this is just a map of just the states that have, I in my draft article say, have rejected deference in some fashion over the past couple of years. We have Delaware, who's been a long time rejecter of deference. It's been decades, and they've consistently said we're not deferring, and so not really talking about them, but the other states here. The green states are the ones that have judicial decisions rejecting deference, and Arizona has a statutory rejection of deference. Florida rejected it via constitutional amendment, and Wisconsin has done both the judicial rejection of deference and a statutory rejection of deference. The judiciary there spoke first, and then after that, the legislator, which had already been debating an anti-deference bill before the judiciary spoke, then the following term after the Supreme Court took action, essentially ratified or affirmed the decision of the Wisconsin Supreme Court. So really diverse, one thing that stands out to me is it's a very diverse group of states regionally. You have Florida in the southeast, you have states in the Midwest, you have states in the West and the mountain states, a pretty diverse group of states that have really moved away from deference. And I think one thing that stands out to me as well is you have some very strong opinions talking about this, really reacting to deference. A couple that stand out to me, one that I love to talk about because I clerked on the Utah Supreme Court when one of these cases came out is Utah, where the court there had a series of 3 decisions, each kind of gradually more and more strongly rejecting deference. The final one being a decision called Ellis Hall, where the court, Justice Lee wrote the opinion for the court, and that was really about our Seminole Rock style deference, deferring to the agency's own regulatory interpretations, but the language there really applies to all sorts of deference. Explained a couple things, a couple of reasons why the court was rejecting deference. First of all, one reason that the Utah court offered is that an agency's regulation or a statute is ultimately the law. And they said the parties have a right to read and rely on the term of these regulations or laws in Chevron type cases. And the agencies lack the right to revise them by a later interpretation. So that's one reason that they gave, is that law is what the text of the law is what controls, and agencies cannot subvert that. The second major reason that they gave was the separation of powers concerns. They said it makes little sense for the court to defer to the agency's interpretation of laws of its own making, because doing so would place the power to write the law and the power to authoritatively interpret it into the same hands, and that would be troubling, if not unconstitutional. So you see really these 2 patterns or trends in the states that have rejected deference. First of all, a focus on the idea of the rule of law, the idea that law ultimately, the text of the law must control. And second, a focus on the importance of the separation of powers, that the judiciary is the one that must make the decisions ultimately of what the law means. One other state that I think is really significant is Mississippi. But Mississippi in 2018 rejected deference for very similar reasons. They said the ultimate authority and responsibility to interpret the law, including statutes, rests with this court. And so they said that it was problematic under the Mississippi Constitution's strict constitutional separation of powers. And I like the language they used. They said that the court was going to step fully into the role that the Constitution of 1890 provides for the courts, and the courts alone to interpret statutes. What I find significant, though, is a recent decision from May 2020. The Mississippi Supreme Court essentially took its stance a step further. It did something that I don't think any other state court, any court that I'm aware of, has done, and it looked at a statute where the legislator called for deference in a particular area. And it said, no, we are not going to defer even when the legislator has called for deference. So that's really a significant step, and something I think we should watch in all of these states and in other states as well, but states that have rejected deference. Do they take it to the extent that the Mississippi court did and say, not only will we not do this as a common law or a prudential matter, but if the legislator asks for it, do we feel strongly enough about our stance that we're going to say that no, the law itself would violate the separation of powers, which is what the Mississippi Supreme Court did in this recent decision. They've emphasized that interpreting statutes is reserved exclusively for courts. So that stance, they're the only state that has done that. I think that's going to be something really to watch in the next years. In these states, in particular, that have taken the step away from deference, what do they do when the legislator requests deference or asks for it? Really goes to the question of what is deference? Is deference a interpretive theory? Or is it something more related to the comedy or respect for other branches? And what happens when the legislator asks for it? Do you then accord it, or do you say, no, the judiciary's role is to interpret the law, and we're not going to give that up in any way, even if legislator asks us to do so. I think that's going to be a really interesting battle to follow and to study over the next couple of years. I'm going to switch to a different map that shows a little bit more color. One second. Show, I think I'm just going to open the full map of the full map with all the states colored, because I don't want to keep having to go back and reshare things. So this is a map. This is the map of all of the states and some territories color coded as well. And so I think what stands out to me is how many different colors I had to code here is really what stands out. There's so many different nuances once you get into the different variations of deference. And it really shows that there isn't really one form of deference that's happening in states, even states that have deference. The red states are the ones that have closest to federal Chevron or our or Seminole Rock deference. They don't have any significant decisions rejecting deference. They don't have any very clear, consistent wrinkles reducing the scope of deference. But even there's still variations in how strictly they apply it, how they talk about deference, what they say they're doing when they apply deference. So it really, I think what stands out to me is the significant variation that exists in all of these states. So in addition to the states that are rejecting deference, you see a whole lot of states that have some kind of limitations on deference. From states that do Skidmore only deference, some form of we're going to defer, which really you can argue, is that even really a form of deference? You have states that do our but not Chevron deference, and this is the thing that surprised me the most. Our-like deference that surprised me the most when I began looking at different states. My sense of reading the scholarship on federal deference is that our or Seminole Rock deference is much more heavily criticized than Chevron deference, consistently criticized. If you think about Justice Scalia, where he was, even to the end of his life, he defended Chevron deference, but he said we might have been wrong on our Seminole Rock type deference, that this deference is not consistent. It seems to me that our or Seminole Rock puts greater constraints on, or is more problematic because it's putting the power to interpret and to enact laws in the same body, going to what the Utah Supreme Court quote that I read earlier said. So it surprised me that there are at least a couple of states that apply only our-like deference and not Chevron-like deference. So I'm interested, I'd love to hear other panelists' thoughts on this if they have a chance, why they think that might be. It seems like an unusual trend to me to have our but not Chevron type deference. And then not going to go through all of these categories, but you have a whole lot of variations of states that defer sometimes or in certain circumstances or more in some circumstances than others. The most common are when there's a high degree of expertise, which makes sense. That's one of the most commonly given explanations for why we would defer in the first place. So this is when a statute is highly technical, when the agency has some degree of expertise that the judiciary would not have, not really interpreting usual terms of legal art, but interpreting more technical terminology, then you would defer. That fits really, I think, with one of the main reasons that proponents of deference put forward for deference. Also, long-standing interpretations in some states get deference, but newer interpretations do not get deference. In some states, that is actually basically, I think, really boils down to not having any real deference at all, because they say only defer if there is some kind of authoritative interpretation of a statute that's stood the test of time. And really that ultimately means there's some kind of judicial interpretation of it in the first place. And so they call it deference, but it really boils down to it has been around and long enough to have some kind of judicial interpretation of it, and it's continued forward, and there's then deference. So in some states that even doesn't really amount to much at all, I think. It's really just a way to say we like what agencies are doing that we've agreed to. But in some states, it means if interpretation is recent, it doesn't get weight. If there's a change in interpretation, it doesn't get weight. So you wouldn't have a situation like a Brand X situation where the agency could change its interpretation and still get deference for a new interpretation or one that went against prevailing judicial interpretation or trends. You wouldn't have deference there. So those are some of the main categories. There's some other variations too, but some of these, what's interesting to me is that it maps really well into some of the debate about federal deference and when you should defer and you shouldn't defer. So states on their own have taken the approach of limiting deference in a way that fits really well with what scholars have argued are the reasons the deference may make sense at the federal level. The other category I want to talk about briefly are states where there's voices of dissent or disagreement about deference, skepticism about deference. And there are quite a few of those. Ohio is one of those that Matthew is going to talk about, where members of the judiciary there have written very significant concurrences or separate opinions or articles just recently talking about Justice DeWine wrote an article recently talking about the topic of deference. So Ohio is one of those examples. The Georgia Supreme Court is another one where the members of the court have said, some judges of this court believe the time has come to reconsider such deference, and they've issued significant opinions saying so. Actually, Georgia, they actually granted cert several years ago to a case to consider deference, and then they decided we don't need to decide it in this case because we believe that statutory interpretation will usually get the right answer. We rarely will ever need to decide whether we defer or not. And since then, they've had a couple of occasions. Just recently, they had one case where they were asked to by several amicus and other parties to decide whether deference should apply. And they said, no, we don't need to do this. We are just going to very strictly apply our tools of statutory interpretation. But they are also likely to eventually have to face this issue and to eliminate deference. And there are several other states that have members of the court that are voicing concern, Pennsylvania and New York, some states you wouldn't necessarily expect, and it's not likely that you're going to have a critical mass to overturn it, but there are going to be continued voices of criticism in those states. Finally, last thing I want to note is that there are a large number of states that I rank as consider inconsistent, where it's really hard to parse what is happening with deference in those states. You have decisions over the years that go both ways. Parties in those states can find precedent in favor and against deference, and the judiciary can do so as well. And one of the states that is Nevada, where you could find a decision just as recently as 2019 saying you have great deference to the states. You can find decisions as recent as 2017 or 18 saying no deference is due to agency interpretations. And in fact, you find that for the same agency, you have decisions going both ways. For the state engineer, for instance, you have decisions saying yes, deference is due to them, and decisions saying no deference at all from the same court within a very short time period. And there are quite a few states like this. And so I think over the next couple of years, we're going to increasingly see states forced to confront this question, especially as litigators ask them to do so, to really examine whether deference should continue, to see whether it is ultimately consistent with the rule of law and the role of the judiciary. So I think there's going to be a lot of movement in several of these states in the next couple of years, and I expect that you'll have more states joining the ranks of those that have rejected deference in the next couple of years because of these trends and because you're going to have more and more states looking at these questions closely. Let's turn to Adi, and he's going to talk about some of the specific experiences he's seen or had in various states.
Thanks, Daniel, and thanks for your excellent law review article. I read that with some interest. I'm going to speak about the state of deference doctrines in states mostly by using Arizona's example, because that's where most of my knowledge and experience comes from. Other than federal law analogs, of course. And my knowledge and experience also comes from being a state official. I serve on the Arizona Board of Dental Examiners, which is a governor-appointed position. It's an occupational licensing board that regulates dentists and allied professionals in the state. And I also serve on the Board of Psychologist Examiners in Arizona. That's the occupational licensing board that regulates psychologists and other allied professionals. That's a Senate-confirmed and governor-appointed position. So I thought maybe it would be interesting to start with sort of a quick overview of recent developments in Arizona. So in August of 2017, the Arizona Supreme Court decided a case called Stambaugh versus Killian. The question involved interpreting a state statute relating to branding of cattle. Now, branding of cattle might be an interesting topic for some other discussion, but what was interesting about that case for our purposes was a pithy concurring opinion written by Justice Clint Bolick. Justice Bolick's concurrence is only 4 sentences long, so I kind of want to read that in its entirety. Quote, I join entirely the court's analysis and outcome. In addition to other arguments rejected by the court, the Department of Agriculture urged us to apply Chevron and defer to its administrative expertise in construing the statute. I write separately only to note that this court has never expressly considered whether Chevron or its progeny established standards for administrative deference under Arizona law. I trust, to the contrary, our constitutional separation of powers remains vibrant, notwithstanding the extent to which the United States Supreme Court has eroded it in the federal context, close quote. Powerful language. So based on this concurrence, this Chevron or its progeny language from Justice Bolick's concurring opinion, there was a lot of interest to amend the scope of review section of Arizona's JRAD Act. JRAD stands for Judicial Review of Administrative Decisions Act. The legislature amended the statute, as Daniel was mentioning, in April of 2018. That's when the governor signed it into law. The new scope of review section went into effect in August of 2018. And full disclosure, I was somewhat involved in the amendment process of that provision. So the new statute reads as follows, quote, in a proceeding brought by or against the regulated party, the court shall decide all questions of law, including the interpretation of a constitutional or statutory provision or a rule adopted by an agency without deference to any previous determination that may have been made on the question by the agency, close quote. So that means Chevron is out, Seminole Rock Hour is out, Brand X is out, and City of Arlington versus FCC is out. So I kind of quickly wanted to also mention sort of a glossary of terms, because some of these may be non-obvious to people who are not familiar with the deference doctrines. So when I say Chevron style deference at the state level, I mean state court deference to agencies' interpretation of statutes. When I say our style deference, I mean judicial deference to agencies' interpretation of regulations. When I say Brand X, I mean deference to agencies' decision to not acquiesce in the court's interpretation of a previous interpretation that the court offered. And City of Arlington, I mean by that is deference to an agency's determination of its own jurisdiction. So we have in Arizona a very, very powerful statutory provision that addresses deference doctrines or ends deference doctrines in the state, at least these 4. And we have seen similar, I have seen similar things happening in Wisconsin by judicial decision, as Daniel was mentioning, and in Mississippi, as again, Daniel was mentioning. Just yesterday, Arkansas Supreme Court confirmed that the state agency's interpretation of state statute is de novo in a case called American Honda Motor Company versus Department of Finance and Administration. So I quickly also wanted to mention, in addition to this trend that we are seeing in these states against deference to legal interpretations offered by agencies, there's also a healthy debate, or at least a trend of a healthy debate at the state level regarding deference to agency fact-finding, among other varieties of docket clearing mechanisms. So at the federal level, for example, the analogs would be Atlas Roofing, which is judicial deference to agency fact-finding, and Turner Broadcasting, which would be judicial deference to legislative fact-finding. So when I use those terms in the state agency context, what I mean by that is in agency adjudications, when agencies engage in fact-finding, courts have become increasingly circumspect in deferring to the agency's fact-finding that occurs through adjudications. In fact, in Arizona, under the JRAD Act, there's a provision that allows courts to have a trial de novo of the fact findings of the agencies. Also, when like the Turner Broadcasting flavor of fact-finding deference, in the state context, what that means is if an agency comes in and puts sort of an explanatory example or a preamble section in its regulations, then that at the federal level, you under Turner Broadcasting, you would just take those legislatively found facts as given. But at the state level, courts are becoming increasingly suspect that those aren't really facts. You still need to establish facts through normal adjudications. So as Justice Bolick pointed out in his Stambaugh concurrence, there are separation of powers problems, obviously, with many of these deference doctrines, almost all of them, but there are also due process problems. And the best place to look for kind of an exposition on the various due process problems with deference doctrines would be Professor Philip Hamburger's law review article, which I believe has become quite famous with the federal judiciary and with practitioners. It's called Chevron Bias. His point is, he makes 2 points. One is that the deference doctrines violate the due process rights of non-governmental litigants. And his second point is judicial acquiescence and bias is dangerous. So I quickly want to mention some of the reasons that the state courts have offered in not deferring to state agencies. And at least this is the trend that I have seen in my experience in Arizona. So there are several dangers, and most of these come from this idea that agencies are engaging in some sort of formal as well as informal adjudication process, as well as making rules at the same time. And in either of those processes, or both of them combined, they are making several findings of fact and several conclusions of law. So then when those kinds of cases come to the courts, what's the court's role in evaluating what the agency has done? So a few things come to mind. One is that state agencies do not follow rules of evidence. This happens with the boards I serve on. We do not follow rules of evidence. There is no protection against hearsay. There is no protection against the mechanisms that are put in place for a fact finder to engage in the deliberative fact-finding process. The agencies do not follow rules of procedure. It kind of gets cobbled together in this notion of informal adjudication or formal adjudication. There's no such thing as discovery or depositions that happen during the agency proceedings, especially adjudications. The witnesses I've seen are not even under oath to tell the truth in these proceedings. There is no right to disclosure of exculpatory evidence. That is just simply not protected. So we have seen a few examples where the regulated party in front of the state agency had to request public records, had to make a public records request, even to obtain exculpatory evidence. And even after that, the regulated party was unable to obtain all of it. And typically these kinds of situations come up when it's typically a staff member of the agency that is exercising the investigatory role of the agency to investigate facts. And then it's the same agency that's wearing the finder of fact hat and finding facts on the record. It's the same agency that's drawing conclusions of law based on those facts. So it's a situation where as Justice Bolick was mentioning, the separation of powers concerns there are that the agency is acting as the investigator, the fact finder, which is typically the role of a jury or a judge if it's a bench trial, is executing the final decision, is prosecuting the final decision, or prosecuting the case against the regulated party. So that's the separation of powers cocktail that courts have become increasingly skeptical about. The other points I wanted to mention, the dangers of agency adjudications and why courts are moving away from this, is that there is no right to jury trial. There is no cross-examination of adverse witnesses. And going to Daniel's idea that, or this idea that Daniel was mentioning regarding agency expertise, in my experience, what we see is so typically in the boards that I serve on and in Arizona boards, from what I have seen, if there is any technical issue, a medical issue, let's say, the boards usually hire consultants to go over the record and review the record and give their opinion. But these consultants have not gone through any Daubert or Fry type qualified expert process, qualified expert witness process. They are not subject to cross-examination. They provide a written report, and the agency heads are supposed to take the report at the face value, at its face value. So in agency deference situations that I've seen, there's this kind of pincer movement where the agency is seeking deference for both its findings of fact and its conclusions of law. And that's why I think courts have become increasingly skeptical of deferring, or as Justice Kennedy at the federal level said, reflexively deferring to the agencies. So I'll stop there. I'm happy to answer questions, and based on my colleagues' comments, I might come back and give some more information. Thanks, Daniel.
Go, Matthew, it's your turn.
All right. Well, thank you to the ABA for putting this on, and to my fellow panelists. I'm enjoying this conversation. As Daniel mentioned at the beginning, I'm an attorney at Jackson Lewis. My views don't necessarily represent my firm's views, and I'm kind of in a unique position where I have to give a second disclaimer. I am a candidate for judge of the Court of Appeals in Ohio, on the ballot in just a few days. I'm unopposed, but the judicial ethics rules apply to me as a candidate. So I'm going to be speaking descriptively about the state of the law in Ohio without offering my own commentary on what I think the law should be. So why Ohio? Daniel mentioned earlier that we have a kind of an ongoing debate, or at least the beginnings of a debate, in our state Supreme Court right now. And I'll talk about the cases that are kind of relevant to that debate in a minute. But I think the practical reason why Ohio interests me is most of my practice is in Ohio. I practice elsewhere, but I'm primarily an Ohio attorney. And I want to start with an anecdote, which I think, while personal, shed some light on some of the issues that arise in these state deference contexts. So a few years ago, I was advising a client, as a nonprofit client, on some issues, and we had to determine whether that client was subject to the state's statute on a particular issue for which there was an analogous federal statute. And under the federal statute, there's most times a nonprofit would not be covered by the statute. There would be a test and some analysis that would need to be done to reach that point. But on the state level, in the state's analogous statute, I found that there was a regulation which covered this coverage issue with regard to nonprofits. And kind of as a surprise to me, I found that the regulation would effectively exclude the nonprofit from coverage automatically, because the regulation talked about coverage applying when revenue of a business was above a certain level, and a nonprofit like this one has no revenue. There's nothing that they sold, so no revenue was coming in. But it was unusual, so I called the state administrative agency, which we can't really do at the federal level, but sometimes you can at the state level. And after my working way through several individuals, I ended up speaking to the individual with kind of chief authority over this area of regulation. And this individual, after I explained the discrepancy and the unusual things that I'd found, basically told me that there was nobody in the agency who had any real knowledge about this particular coverage issue, that she had been unaware of this exclusion before, but that, as she told me, well, I think what we should just do is just say that in your case, I know it says revenue in the regulation, but let's just say that you should look at the budget. And if the budget is above the amount of revenue that's in the regulation, then we'll say you're covered. Now, this was never, this kind of on-the-fly verbal statement was not actually put into a rule or an official agency or interpretation. But this experience, I think, kind of illustrates some of the differences between dealing with state agencies and federal agencies. And we'll get into some of those in a minute. But the question, I think, would be, let's say that she had, proceeded internally and the agency had issued that a rule that complied with what I was told verbally. What sort of deference would be owed? And in Ohio, there's some debate, but several of our justices on the Supreme Court, I think, would tell you that it's unclear. And this unclear nature of deference in Ohio really came to the foreground in a case decided in 2018 called State ex rel McCann versus Delaware County Board of Elections. Now, this was an elections law case where you had a local community that had a initiative on the ballot, and there were questions about whether the initiative should remain on the ballot. It had to do with the collection of signatures on a petition that under Ohio state law is necessary in order to get an initiative on the ballot. And in the case, the court actually split. You had a per curiam. By the way, the court in Ohio, the Ohio Supreme Court has 7 justices. You had a per curiam decision of 3 that was essentially the opinion of the court. You had a concurrence by 2 that agreed with the per curiam decision on different grounds, and you had a dissent by 2. But the interesting thing is that the concurrence and the dissent, while not presenting an actual opinion of the court, did agree, 4 of 7, or at least seemed to have agreed on some questions about deference. The concurrence was written by Justice Pat DeWine and joined by Justice Pat Fisher. And Justice DeWine engaged in a lengthy discussion of clear guidance or unclear guidance from the Ohio Supreme Court regarding the level of deference owed to administrative agencies. The level of deference was relevant here because the per curiam decision was relying on the Ohio Secretary of State's interpretation of the statute that concerned the collection of signatures on a particular petition form. Justice DeWine wrote that, quote, in an appropriate case, we ought to take a hard look at our practice of deferring to statutory interpretations made by administrative agencies and non-judicial officials. And he explained why at length. He talked about concerns that he had about deference potentially being at odds with separation of powers principles that have already been discussed by Daniel and Audie. And then he noted that the Ohio Constitution explicitly vests a judicial power only in the state's courts, of course not in administrative agencies. And he noted the ongoing debates about Chevron deference at the federal level within the federal courts. He also engaged in a bit of a review of deference decisions that the Ohio Supreme Court had issued in the past. And he argued that while the Ohio Supreme Court had cited Chevron in several cases, it may actually be the case that the Ohio Supreme Court's approach to deference is more deferential to administrative agencies than is the case under the Chevron doctrine, because the Ohio Supreme Court has in several instances applied deference even where there was no finding of ambiguity under the statute. The dissent in that case was authored by Justice Sharon Kennedy and joined by Justice Judy French. And while they disagreed with the outcome regarding the petition, Justice Kennedy went out of her way to say that I will leave for another day the issue whether the judicial branch truly owes deference to administrative agencies' interpretations of statutes. And she didn't just say, I'm going to delay deciding that issue. She went further and cited U.S. Supreme Court Justice Anthony Kennedy's concurrence in Pereira, which I can never say, versus Sessions, specifically his concerns about separation of powers as it relates to judicial deference to administrative agencies. So after this decision in McCann, what we have is a situation where 4 of the 7 justices have seemingly expressed a willingness to re-examine the state's doctrine, if there is one, to deference at the state level. In the next year, in 2019, there was a second decision where this issue arose involving Ohio Edison, a power company. And in that case, again, you had several opinions issued by the court. I think you had a plurality, a concurrence, and 2 dissents. So you don't quite cobble together a majority on this deference issue, but Justice DeWine again raised the issue and pointed out that the court had not really addressed deference. And in his view, in that case, the lead decision from the court was applying Chevron deference to the issue of what is an incentive when there was really no ambiguity. In his view, the word incentive is in common usage and didn't really require any agency interpretation. Notably, since McCann and Ohio Edison, I've taken a look at decisions from the Ohio Courts of Appeals, the intermediate appellate courts in Ohio, and you actually have not seen any real discussion of either of those cases. There's 2 cases that most importantly have discussed deference. The first, Defender Security Company versus Testa, which was decided by Ohio's 10th District Court of Appeals, cited several Ohio Supreme Court cases and said it's simply, quote, axiomatic and, quote, a fundamental tenet of administrative law. The courts have to defer to state agency interpretations of state statutes unless those interpretations are not reasonable. Though the court did include a see also citation to Chevron, the way this District Court of Appeals discussed the issue included no reference to ambiguity as a initial hurdle that had to be met before deference needed to be applied. But in a second case decided after these 2 Ohio Supreme Court cases, State versus Levine, Ohio's 4th District Court of Appeals was faced with an argument that a police officer did not have the authority to make a particular traffic stop. And as part of its discussion of the meaning of the word at, as in the vehicle must stop at the stop sign, the court stated that its interpretation was consistent with the State Department of Transportation's interpretation of the traffic statute with respect to highway markings and signs, and therefore the agency's interpretation had to be given deference under Chevron. But while the court referred to Chevron, it never explained why Chevron deference may be relevant or need to be followed in this type of context. It was simply assumed. So in other words, despite the Ohio Supreme Court's virtual invitation, or at least 4 justices' invitation to clarify what type of deference is owed, if any, these 2 state appeals courts simply made assumptions about Chevron deference, or something similar to Chevron deference, without wrestling with the questions raised in McCann and Ohio Edison. So 2 years later, the issue remains unresolved, but it's clear it's not going away. Literally this week, Justice DeWine published it's a blog post in the Yale Journal on Regulations blog, in which he elaborated on his thoughts in McCann and Ohio Edison. We didn't know that was going to come out this week. It's just a fortunate timing coincidence. In this post, Justice DeWine points out, he elaborates further on why he thinks that the court needs to re-examine deference in Ohio and why he thinks that the court does not really have a clear judicial deference doctrine. But he also points out for the first time that Ohio Revised Code section 1.49 sets forth 6 items that courts may consider, among other matters, when a statute is ambiguous. One of those factors is the administrative construction of the statute. And Justice DeWine suggests that the plain language of section 1.49 means that a finding of ambiguity must come before a court is permitted to consider an agency's interpretation. And he notes that while he thinks this statute is relevant to these questions, the Ohio Supreme Court has never discussed or cited section 1.49 at all in the deference context. And I would, I'm going to raise some issues without kind of explaining where I think they might come out, because I think it's important to note that there are a number of structural differences at the state level, at least in Ohio and presumably in other states, that presumably would come into a question of what level of deference is owed, in addition to in Ohio Section 1.49. So for example, several decades ago, Ohio created something called the Joint Committee on Agency Rule Review. It's a committee that contains a few members of the Ohio House and a few members of the Ohio Senate. And when an agency in Ohio, about 120 of them are subject to JCAR, when one of those agencies wants to issue a new rule, they have to submit the rule to JCAR for review. And JCAR has the authority to review new and amended rules and rescissions of rules. And it's specifically tasked with determining whether a rule exceeds the authority that was delegated to the agency by the legislature. It also examines whether the rule exceeds the agency's statutory authority, whether it conflicts with legislative intent, whether the rule complies with certain requirements, such as the preparation of a business impact analysis. And JCAR has the option of recommending to the General Assembly that the rule be invalidated based on those concerns. If JCAR makes this type of recommendation, the General Assembly can invalidate the rule by concurrent resolution if it passes both houses, and the agency is then barred from filing a rule on the same topic during that General Assembly. Notably, rules don't go into effect until they have left JCAR's jurisdiction, and the agency files the rule in its final form with JCAR and a few other state bodies. The important thing here is this: there's no analogous body to JCAR at the federal level, at least not as JCAR is structured. While I've reached no conclusions myself, it seems that the involvement of JCAR in reviewing and potentially recommending that the General Assembly block agency rule-making action is a relevant issue that would apply to the question of what level of deference may be owed to regulatory rulemaking in Ohio. But again, based on my search, I've never found a court opinion in which JCAR's relevance to the level of deference that it owed is ever discussed. Likewise, it's worth noting that discussions of deference, as has already been discussed today, usually involve some discussion of the level of specialized knowledge that administrative agencies have with regard to a certain specialized topic. But I think it's a fact, an indisputable fact, that state agencies have smaller budgets, smaller staffs, et cetera, than do federal agencies. You can look back to my example, my anecdote I shared at the beginning of my discussion, where this agency told me that they really had nobody with knowledge of the particular coverage issue that I was asking about, but I was given some guidance by the agency as to how this agency official thought the agency would rule on the issue. This difference in structure, in budgets, in staffs, et cetera, may be another factor that hasn't really been discussed when it comes to the level of deference, at least discussed in the courts in Ohio, that comes to the level of deference that may or may not be owed. It's clear that Justice DeWine, Justice Kennedy, Fisher, and French in Ohio have raised, or at least signaled, willingness to discuss these issues. And I've raised some additional points that probably deserve some discussion in Ohio, at least. And I think that there are probably similar points that can be raised in other states, both state statutes that deal with the interpretation of texts, agencies like JCAR, et cetera. But there's really no answers at this point. And this just, at least in Ohio, it just serves to illustrate why we're having this discussion, and the fact that it looks like over the next few years, we may develop some new guidance on deference in the state courts. So thank you for your time. I look forward to the questions.
Thanks. Let's have Aaron, go to Aaron now.
Hi, everyone. I want to also to say that I'm glad to be here and to thank the ABA and my fellow panelists, and to thank Daniel in particular, who's been our moving force, and at the ABA who's made it happen. Going last is a hazard, of course, because one always finds oneself preempted by the people who preceded, and that certainly is true in my case. So I think part of what I want to do is follow up on some of the things that Matthew have said, which are all over my notes, but I hope you'll bear with me as I try not to be repetitive. I wrote a paper some years ago, I guess it was 2014, about this topic, in which I noted two trends in the states in 2014 about which I was pleased. One was an increasing trend not to be utterly haphazard about deference and to develop deference doctrine at all. That's an important piece of progress. It was, of course, true in federal law for a long time that was true, right? Chevron, until Chevron, that happened in the federal courts, and arguably it continues to happen to this day, especially in the Supreme Court of the United States, where deference doctrines are made up as one goes along. But I do think it's a very salutary trend to think about a rule for agency deference that's a principle rather than a off-the-cuff conclusion. So I was pleased about that, and I was also pleased that when I looked at the surveys like the one that Daniel has done now in 2014, there was already a noticeable trend away from the adoption of Chevron deference. As a person who had been and continues to be roundly persuaded by Justice Scalia's defense of Chevron, the point I wanted to make at that time was that one can be entirely persuaded by Justice Scalia and his view of Chevron and still think that Chevron is not a good doctrine for the states. And the idea here is that Chevron is really a bespoke piece of doctrine that is very carefully adapted to the particular federal context, and that those contexts are different in the states, and therefore even someone who loves Chevron in the federal context, to use a strong word, but I might be such a person, would not necessarily need or want to think that similar principles were relevant at the state level. And I went through a number of factors that could persuade one of this position, including some of the ones that Matthew talked about and other ones too. The election of judges, of course, is one of those factors. The non-unitary nature of most state executives is one of those factors, since the defense of Chevron rests so heavily on a unitary executive idea. In particular, that agency heads themselves are elected for a good number of state agencies, giving them an independent political constituency is a very important difference. And rules review in both, I'm now adapting on the fly since Matthew's introduced this topic, but it is true that in a majority of states there is rules review either by the legislature, which is the most common arrangement, or by the governor, or by some kind of hybrid authority, as Matthew has just described. Again, we don't have that at the federal level, or at least not at a statutory level. The state attorney general with an independent political constituency who makes his own judgments about what the law is on behalf of the state without either control over the agency or control by the governor is an important difference. And I want to say something also about federalism at the end. So there's a long list of reasons to think that even if, and I'm not trying to argue for Chevron here at the federal level, but only to say that even if one thinks that Chevron deference is good doctrine in federal administrative law, it's not good doctrine for the states. And my conclusion in 2014 was pretty modest, which was, not that it's bad doctrine for the states, but what the states want to do is think about these kinds of issues and thinking about how deference ought to proceed at the state level, and to ask themselves these kinds of questions about how the institutional and constitutional differences between the state and federal contexts might lead them to take their own differences seriously and come up with doctrines that were appropriate. So 6 years have gone by, and Daniel invited me to do this, and I just wanted to take an early opportunity as I'm thinking about this again, and I'm starting to work on it again, to say that the biggest change now, in addition to the sort of progress of those trends of of not following, not adopting Chevron wholesale and more explicit attention to this issue is that in the legal community at large, which means all of us, including what's happening at the federal level, now, in addition to the narrative of Chevron being a dominant narrative, so too is the narrative that Chevron is wrong, a dominant narrative at the federal level, because we are now in a situation where the profession in general, led, I suppose, by Justice Gorsuch, but also plenty of other figures, Professor Hamburger among them, who are arguing against Justice Scalia and against Chevron for a set of reasons. And what I want to say about that is, just as the states should not adopt Chevron in a reflexive way, so too they should not adopt the Chevron critique in a reflexive way, but they should take note that the Chevron critique is also based on idiosyncratic features of federal governance which are not duplicated in the states. And so I want to try to be fairly brief, and I just want to say a couple things about a few institutional features that make me feel strongly that at least that the Chevron critique that's going on in the circles of people, judges, lawyers, government officials, and academics who talk about Chevron deference at the federal level, that those critiques need to be substantially revised for the states. The most important is that separation of powers does not have to mean the same thing in the states as it does in the federal government, and indeed it shouldn't. Here we face a good deal of variety, and it pushes in both directions. So the most important plank of the anti-Chevron critique, which is to say that deference interferes with the judicial duty to say what the law is. This takes advantage of the old pre-Chevron connection that was drawn between deference and Marbury by Henry Monahan in particular. States have different constitutions in this regard. So one thing that pushes even further away from deference is the fact that some state constitutions are explicit about not deferring to agencies on the part of the courts, and this makes it quite easy and quite different argument than it is at the federal level that deference is not appropriate. But there are also several reasons to think about separation of powers in ways that might make you not quite as ready to adopt the idea that Chevron is an obvious violation of separation of powers, and in particular of judicial prerogatives. And I want to mention three. One, that the election of judges, the political scientists, and I think many lawyers too, notwithstanding, I think, quite principled behavior by the vast majority of state judges on this in this area, I think it's still widely believed, and I believe, that life terms and tenure protection and salary protection preserve judicial independence in a way that fixed terms and elections do not. And so one concern at the separation of powers level has to be that state judges are, in many, but not all states, more political than they are at the federal level. They don't have those institutional protections. They aren't thought of as entirely as far away from partisanship as judges are at the federal level. And this ought to, I think, influence the way we think about whether review should be de novo by a judicial branch which is somewhat closer in some ways to the making of policy and to politics. That's one, in many ways, the weakest one. The second one I want to mention is I've already mentioned the election of state agency heads, but I think that combined with the institution that Matthew was talking about of rules review is a very important institution to think about. In those states where the legislature has either the prerogative or the duty to pass on the legitimacy of rules before they go into effect, one important concern about deference goes away, which is that the agency has misread the legislature, right? And so if one has the legislative imprimatur on an agency interpretation, either by implication or directly, then the political theory concern that underlies a great deal of deference doctrine, which is to limit the power of agencies to go their own way, right, has been solved by this other institutional problem. And so one can see in an agency interpretation a very different level of democratic accountability and legislative supremacy that one worries about at the federal level. And this, I think, is a potential argument, depending again on your state, to be more willing to think about deference to agencies in the state rather than in the federal context. And I'll just mention one more, and then I have more things too, but I do want to, I'm watching the clock, and that is I think it's fair to say that one of the great concerns about deference at the federal level is that deference has contributed to an undesirable growth of the scope and aggressiveness of the administrative state. And that one way to control agencies arrogating power to themselves and then getting deferred to, right, which is essentially the phenomenon that we're worried about, so that agencies increase their scope and then it's hard to knock them back down because you're required to defer to them. At the state level, that's not the same phenomenon, and the reason for that is the existence of the federal administrative state. So to the extent that state agencies are in many ways subservient, but nevertheless partners of their federal counterparts in regulating all of the policy areas over which there's concurrent federal and state agency jurisdiction, a contraction of state agency regulatory power is equivalent to an expansion of federal agency regulatory power. And for those who are concerned about deference because they're concerned about the size of the administrative state, this is a factor that I think, like these other factors, really needs to be thought of and thought about carefully before one concludes that the separation of powers judgments that one makes at the state level have and can be expected to have similar effects in relation to things like limited government at the state level. I guess I do want to say one thing about the third thing on my list, even though I'm very close to the end of time, which is that the analysis that Matthew referred to about the particulars of the Ohio Act, this really needs to be done on a state-by-state basis very carefully. The Model State Administrative Procedure Act is actually more deference-friendly than the Federal Act because there's a comment which explicitly says nothing in our language, which roughly tracks the federal APA, should be considered to derogate the ability of state courts to engage in judicial deference. But that is not true of the individual state administrative procedure acts as enacted, where there really is a diversity of language. And it's extremely important to, when one takes Justice Gorsuch's claim that deference is inconsistent with the APA, Section 706, you can't import that argument into the states. You have to be thorough and careful with respect to your state codes. I do have more things, but I will hold them. And I just want to conclude by saying that at our moment, the critique of Chevron has taken on a strongly partisan flavor, which was not true when Chevron was introduced, right? When Chevron was introduced, it was an issue that really did not follow partisan lines. Chevron, of course, itself was uncontroversial when it was decided. But given that the critique of Chevron has taken on this partisan cast, I think it's particularly important to be careful and specific and institutionally precise as one takes account of that critique in the very different contexts that the states offer us. I thank everyone for their attention.
Thanks, Aaron and Matthew and Adi for really great presentations, and I think really raised a lot of really interesting questions, some of which I hadn't thought about, and really excited to discuss further. Reminding people that are listening in that you can ask questions in the Q&A. We've seen at least one question in the chat, but if you want to use the Q&A feature, you can ask questions. I think given the time, we can discuss a little bit in the panel, and then we can give some people some time to ask some more questions or raise some more suggestions. So think I can begin by just making a couple of comments about the other presentations. What stood out to me as really interesting is that Adi, Matthew, and Aaron, you all mentioned factors that make states different than the federal government. Some of which point in favor maybe of deferring, and some of which point against deference. And so I thought that was really interesting. Between all the presentations, there's a question of, are agencies really doing the same things in the states? Are they really as expert as a federal agency might be, to the extent the federal agencies are expert? Are they maybe more partisan or more susceptible to political pressure, or less likely to do intensive fact finding? More likely to just go on the fly. And then on the other hand, I think that Aaron raised some interesting comments about the state judiciary perhaps being less expert or less capable of engaging in nonpartisan statutory interpretation. So I think those are just really interesting factors that point both ways. I think it's something that very much deserves further exploration. I agree that I think it's a really interesting question to take a closer look at it. And I agree that courts haven't really done so very carefully. Those that have rejected deference, they haven't really talked about what makes states particularly different than federal governments. With the exception of one thing that I don't think was mentioned, or maybe it was, but I missed it. The Utah Supreme Court mentioned that one thing that is different is that there's not a danger of different opinions about the meaning of a law if you have a unified judiciary in a state, and that's a factor that pushes against deference, according to the Utah Supreme Court. That you don't have conflicting precedent ultimately. You don't have 11 federal courts of appeals and lots of state courts. Especially in a smaller state like a Utah, you have really a very streamlined judiciary that goes from trial court to the Court of Appeals to the state Supreme Court, and there isn't as much opportunity for conflicting opinions to fester or percolate for a very long time, which to me is a good argument against deference at the state level, because you don't have the same concern of, if you don't defer, there's going to be different opinions, different parties being subjected to different rules over time. You're going to have more, it's going to increase uniformity rather than decrease uniformity. So that's one factor I didn't hear mentioned that stands out to me as relevant. I thought, Aaron, your idea that Chevron is a bespoke doctrine for the federal government was really interesting. The idea that it was tailored for the federal government. I think you're right that we need more exploration of that and discussion of that. So I thought that was really interesting. And then one last comment from me is that the comment by Matthew about the Joint Committee of Agency Rule Review. It seems like a lot of states have variations of that, but they differ in what the state does. I know in some states, Idaho and West Virginia in particular, the legislator has to ratify the rule, or it doesn't go into effect, or they have to every year in Idaho now review rules and give them assent. And that seems different to me than maybe what you mentioned, Matthew, for Ohio, which is they can make a concurrent resolution, but if they don't act, the rule goes into effect. It seems different than them having to take positive action. In what degree maybe deference should be due, or is appropriate to think that this is really the legislator ratifying it. Legislators don't act for a lot of reasons, and concurrent resolution still needs both chambers of a bicameral legislature to agree on something. So it's still requires affirmative action to get rid of a ruling, of a regulation or interpretation. So I think it's different than something that they have to do in order before the rule goes into effect. So those are my comments. Have the other panelists who have shared their thoughts as well, and again encourage anyone who has questions to share them in the Q&A or in the chat, but preferably the Q&A.
Daniel, can I make a couple of comments?
Yeah, please.
Thanks. I actually kind of wanted to go back to something I mentioned regarding due process being a concern in all of these things. I touched upon sort of some of the differences in procedures that the agencies use at the state level. Now, at the federal level, you have a slightly different system. I mean, there are some problems at the federal level, obviously, but Keeping those aside, at the state level, the things like not following rules of evidence, not following civil procedure rules, not making exculpatory evidence available, not advertising witnesses, not really having a formal adjudication process, meaning a process that people usually take for granted when they go to court, is simply not available at the state agencies. So that's something that I found really interesting in terms of the difference between state adjudications versus federal adjudications. And I think that's a factor, the due process concern is a factor that goes very heavily in favor of not deferring to state agency adjudications or any fact findings or conclusions of law that come out of those processes. And the reason for that is, I mean, imagine a case like in re Galt, which was incidentally an Arizona case, which some 50-something years ago, where the US Supreme Court looked at the lack of procedures in place for juvenile delinquency proceedings. So these juveniles were going through this system. They were being incarcerated without the civil procedure in place, without rules of evidence in place. And that's exactly what we're seeing in the state agency context, at least in Arizona. We just simply don't have rules of evidence apply in state agencies. We don't apply civil procedure rules in state agency adjudications. And I think the trend has been, or should be if it isn't, is to look at what the US Supreme Court did in re Galt. They said this lack of procedures is a due process issue. I mean, there are separation of powers issues, to be sure, but there's also the due process concern there. And in re Galt stands for the proposition that you need those basic, fundamentally fair procedures in place. And I mean, to Aaron's point as to whether this maybe is partisan, maybe is not. I would say from what I have seen, it's unfair to both. For example, in a dental board context or in a psychologist board context, it's typically a patient who is the complainant and the regulated party is the respondent. And the lack of procedures is unfair to both the complainant and the respondent. So I'll push back on this notion that Chevron or discussion of deference has become partisan, because lack of those fundamentally fair procedural due process protections is unfair to all parties concerned. It's even unfair to people who serve on the board, because they're often accused of making these decisions, finding facts and concluding, making legal conclusions. So it's unfair to everyone concerned. And one last point as to the differences. I think the focus of state deference, trends in state deference doctrines, has been on Chevron style deference. And I quickly also wanted to mention that perhaps the more egregious doctrines out there are doctrines like Brand X deference, which, again, full disclosure, last year at the New Civil Liberties Alliance, I was counsel of record asking the US Supreme Court to revisit Brand X. The court denied cert, but Justice Thomas wrote a dissent and walked back from his majority decision in Brand X. And Brand X is really a curious deference doctrine, which I'm actually glad that state courts have not adopted something like Brand X. And in Arizona, because of the statute, Brand X is out. And Brand X really is egregious because what happens is a state court decides something. A state court, let's say, comes in and says, this is what the law means, this is what the statute means. And if the agency then comes in and ignores principles of stare decisis, ignores the judicial decision, and comes up with a totally different interpretation, Brand X at the federal level would suggest that the federal court should then defer to the second in time agency interpretation. So I'm really glad to see, at least at the state court level, there hasn't been that kind of gamesmanship that state agencies have engaged in. And one final point to this notion that there are some state agencies. So, for example, like Matthew was mentioning, there is a state agency in Arizona called the Governor's Regulatory Review Council. So that's the state agency that evaluates or reviews all of the rules that the state agencies pass And after that review, they become final and effective. So the role of GERC, as we call it, GRRC, is quite narrow from what I've seen. I mean, they basically make sure that you're following all of the procedures. They don't really look at the substantive aspects as to whether the agency is properly or is not properly interpreting the statute or its regulations. So to the extent that these agencies like GERC are viewed as reasons for then the state courts to defer to the state agency interpretations, I think that's a flimsy reason for the reasons I mentioned. So I'll stop there with my comments. Thanks.
Matthew, did you want to offer some comments on any of the other presentations?
No, I don't think I have anything right now that hasn't been said. There's a couple questions I noticed below.
Yeah, I see a couple. Let's see. So I see one in the chat, which I think
can I respond to?
Oh yes, of course. Sorry.
Just very quickly, I think I want to make a brief response to one point you raised and one point Adi raised. With respect to Adi's point about adjudication, I confess I'm not quite sure why this is a deference problem. This sounds to me like a straight up problem with informal adjudication that's too informal and a mistake in deciding how much process is due to informal persons who are participating in informal adjudications. I'm not quite, it seems to me at least that it would be possible and plausible to address those issues without hitting the deference problem in most cases. And I just want to say one thing about the uniformity argument that Daniel alluded to with respect to the circuits, which I admit is new to me and is interesting, although I want to think about it more and I need to read that opinion. But I do want to add that there is a non-uniform issue in the states, which is not present at the federal level, which is the home rule local jurisdiction. And so because there are local governments with constitutional status and regulatory powers that are also engaged in a process that's like the construal of state statutes, you do get, I think, the same kinds of non-acquiescence and conflict problems that we see in the circuit. Certainly not exactly the same kind, but they're analogous enough that I'm not quite ready to say that that state jurisprudence is a field of uniformity relative to the federal. And I do want to get to the questions from the audience, so I'm going to stop there.
I will, sorry. I will jump in with one thing, because Aaron reminded me about this point about the state courts. Ohio is a state where our courts of appeals, we don't have one court of appeals as some states do. We have a district system, 12 districts, similar to the federal courts. So in that respect, we do have a system where you may have, competing ideas about deference that may need to eventually, ultimately be resolved by our highest court.
Great. So I'm looking at, I see one question in the chat, which is about the Government Accountability Office and the Congressional Review Act, and how similar is that to the Ohio Joint Committee of Agency Rule Review, or for that matter, to the Arizona model that Adi talked about. I don't know who anyone feels strongly about wanting to address that question. I'm not an expert at on the CRA as some other folks at Pacific Legal are, but I'm curious if anyone has any expertise on that, or if not, I have a couple thoughts, but I wonder if anyone feels strongly about answering that one.
So I can get started. I actually don't see a lot of parallels between the GAO or the Congressional Review Act process and the Governor's Regulatory Review Council process. And the main distinguishing characteristic is really the way the statutorily GERC is structured. I mean, they have a very specific and narrow role. It's mostly like a checklist system where they have to go down this checklist of 7, 8 factors, 11 factors, I believe, and see if the agencies have done all of those things. And the things that GERC typically considers are whether there has been a notice of proposed rulemaking, whether there has been stakeholder input, whether there has been some cool down period over which the agency heads have studied the rule proposals, and is there any inbuilt period where there is time for agency heads to formulate opinions or policy positions on proposed rule changes. And none of these factors really go to the heart of this deference doctrines issue that we are facing, because the courts at that point can't point to the GERC process and say, because GERC has rubber stamped the rulemaking process, therefore the agency's interpretation should be okay, or we'll just defer to it. And that just simply is not the role of GERC. So in that sense, I mean, to the extent these state agencies can be stand-ins favoring deference, I just don't see that, at least in the Arizona context.
One comment of mine about the congressional, sorry, Congressional Review Act is that the big fight over the CRA is right now is over what it applies to and what exemptions, what is exempt from the scope of the CRA. So I think that a lot of the battle at the federal level, at least, is does the CRA apply at all? And if it does, it's somewhat at the moment somewhat toothless in terms of actually requiring any substantive evaluation. I think it does have a sort of an important role. Right now, the agencies tend to argue that the CRA just doesn't apply to what they do, and they sometimes get away with that, at least, of just not submitting something to the Congress at all. So it's easier to circumvent, perhaps, than it might be in a state where the rule, it sounds like Matthew, you described in Ohio, is that the rule just doesn't go into effect until it's gone through this process, and so there may be some limits to the CRA's scope.
Right. I think there's a key distinction that distinguishes Ohio's JCAR from the GAO, Congressional Review Act process, and that's that with JCAR, as distinguished from the federal, there's not a report that's being submitted to the entire legislative body. Rather, in Ohio, the rules are presented to JCAR, which has just a few members, some of whom are from the Ohio House and some of whom are from the Ohio Senate. So you have a subset of legislators that are reviewing these rules and making a decision as to whether to bring the rule before the General Assembly at all. That's, I think, structurally different. Whether that's significant, I'll leave that to others, but it is a different type of process.
I don't disagree with any of my colleagues, but I want to to acknowledge that the questioner is onto something, I think, here, which is that there is sort of fetal embryonic infrastructure in the federal government for the kinds of processes that are much more mature in many of the states. Both the Congressional Review Act, not just the GAO process, but the whole act, and also the analog of gubernatorial rules review, which is the Office of Information and Regulatory Affairs, which again doesn't have the kind of powers or institutional status, institutional arrangements that the gubernatorial arrangements do in many states. But some of the infrastructure is starting to exist for this kind of thing. It is definitely more mature in the states where it's mature, and in particular in the states that Daniel mentioned, where it's not, there's not even a presumption of validity in the rules until there's legislative assent. But that's not an embryo ready to be born by any means, and especially a lot of questions would have to be answered about the institutional capabilities of the Congress. But nevertheless, there is some movement in that direction. I think that the questioner is right to see that as a development, which is perhaps slow in taking hold, but that's ongoing.
I agree. Other question we have is kind of two related questions: is would we feel differently considering a state agency that used a procedure similar to formal rulemaking under the federal APA? And as a companion question, how prevalent are formal rulemaking procedures in state agency practices?
I definitely don't know the answer to the second question. I mean, the conventional wisdom in administrative law, sort of academic administrative law circles, is that formal rulemaking under the APA is so unwieldy as to be nearly useless. and in most contexts. And given that informal rulemaking is now a process that takes between 3 and 5 years, I'm sympathetic to that view, but it has been long enough since it's been tried in more than a very occasional way, if that, I have to look, that I don't think we know the answer to that.
Yeah. I suppose one could wonder, is notice and comment rulemaking at the state level what the equivalent of, I mean, is that the formal rulemaking at the state level? I think that seems like that is the formal rulemaking from most states I'm familiar with. I'm not aware of a separate, more formal process that gets used than the kind of notice and comment equivalent. But so that seems like the standard in most states I'm familiar with. Certainly don't have a sense of every state on that at all. So I guess what difference might that make in our thinking about whether deference is due or not due to an agency if there's this formal rulemaking process that's more formal than the notice and comment process, if any?
I think, unfortunately, I'm going to have to take the easy way out and say, you know, I acknowledge there could be there are differences between those two, but what impact do they have? I probably shouldn't comment because the rules I mentioned earlier.
I can maybe venture somewhat of an answer. I don't think this is a complete answer to the question, but I think, I mean, so for example, in Arizona, we have a formal rulemaking process, and almost all rules have to go through that process. There have been some executive orders issued by the governor in place that put moratoriums on rule changes, and you have to get an exception from the moratorium before you can even go through formal rulemaking. And the trend definitely in Arizona is almost always formal rulemaking, unless, you know, lightning strikes. I mean, it's really, you know, formal is the way to go. But there is also an informal rulemaking process. They call it substantive policy statements. But the counterpoint to that is statutorily, any substantive policy statement does not have the force and effect of law. And if any party can directly go to court challenging a substantive policy statement as infringing upon some statutory or constitutional right. So there is a point and a counterpoint to the rulemaking process. And ultimately, I think when you look at the JRAD Act, the Judicial Review of Administrative Decisions Act in Arizona, there's definitely this notion that regardless of what rulemaking something goes through, it is still the final interpretation of a statute or a regulation that the agency is putting forth, and that interpretation should receive de novo review. It should not receive any deference. At least right now, after August 2018, that's statutorily absolutely true.
Thanks, everyone, for the comments and participation, and to the audience for the questions. I think this has been a great discussion, and I think it's going to be a topic we're going to have to revisit as trends change. States keep moving. I did my 50-state survey in March, and I've been updating it since then. And since then, you've had at least Arkansas moving away from deference. You have movement in other states. I think this is going to be something that we're going to increasingly see a need to revisit and to discuss. And so I'm looking forward to that as well.
Thank you, everyone.
Thank you very much.
Thank you. I've enjoyed it.
Thanks, everyone.